Okay, great. This seems to be working. Okay. Good afternoon, everyone. I'm Hearing Officer Sam Bivens with the Administrative Hearings Office of the State Water Resources Control Board. This is a status conference on water right application 30166 filed by Elsa Ranch for a permit to appropriate water from the Big Sur River in Monterey County. This status conference is being conducted by Zoom webinar and is also being broadcast live on the AHO YouTube channel. Both the audio and the video are being recorded, and we will post files of this recording along with the Zoom-generated transcript to the AHO FTP site. And the YouTube recording will also be available on the AHO YouTube webpage. If at any time you're experiencing technical difficulties trying to communicate with us, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. AHO staff will be monitoring the email inbox. And with me today are several staff of the Administrative Hearings Office. We have Rebecca Stolfus, Sam Bullen Bryan, Nicole Mullen, Skylar Anderson, and Kyle Woldridge. Thank them for being here today. And with that, let's move to appearances. So as with the last one, we did this in April, we had just switched to the Zoom webinar, and that worked reasonably well, I think. So as I call on each of the parties, I'll ask that each party's lead representative raise their hand, and we'll promote those individuals to panelist status, which will allow you to talk, appear on camera, etc. Once you've been promoted to panelist, if we get to a point where you need one of your colleagues to also be a panelist to talk about an issue, we can go ahead and do that at that time. We'll just keep the one lead representative for each party at this time for speed and efficiency purposes. But if you do need one of your colleagues to be able to appear, just let us know and we'll do that. And then as we proceed, just please keep your microphone muted except when you're speaking so that we can minimize background noise. And once we get through this, I think we'll proceed pretty quickly through the status conference. So starting with Elsa Ranch and James J. Hill III, I see Ms. Ainsley, but if the lead rep for the applicant could raise their virtual hand, we'll go ahead and get them promoted. And there is Ms. Ainsley. Good morning, Ms. Ainsley. I'll take your appearance, please.
Julianne Ainsley for the applicant, Elsa Ranch. With me today should be Mr. Berliner. I'm not sure. I obviously can't see the participants. Mr. Blum and Mr. Harrington, as well as the consultants from Montrose.
Yes, and I see all of those people. And go ahead, Ms. Ainsley.
I would prefer if you would promote at least Mr. Berliner to and Mr. Harrington and Mr. Blum can raise their hand, but in case I need Mr. Berliner to chime in with any additional details, since we tend to split up tasks.
Yes, understood. Let's get Mr. Berliner promoted to panelist, please. And then let's also get Mr. Schwartz, because I'll have my usual CEQA update question, and he may be able to provide some input on that. And then if we need anybody else, we'll go ahead and get them on then. All right, and there is Mr. Berliner and Mr. Schwartz. Okay, very good. Thank you, Ms. Ainsley. California Sport Fishing Protection Alliance, yes, there's Mr. Schutz. Let's go ahead and get him promoted, please.
Good morning, Chris Schutz for the California Sport Fishing Protection Alliance. I expect that John Busey with Center for Biological Diversity will also be on. It would be good if he was promoted as well. Thank you.
All right, we will get him on there when we get to CBD, which is next on my list. Before we do that, Mr. Schutz, will you be appearing on behalf of any other parties today? That seems to be a theme with these conferences.
I would check in with Mr. Busey on that. I mean, I could report back to Trout Unlimited, but I'm not appearing on their behalf formally.
Okay. Very good. Thank you. Thank you, Mr. Schutz. All right, Center for Biological Diversity, and I see Mr. Busey, and let's get him promoted, please.
There we go.
Good morning,
Almost.
Mr. Busey.
Right. Thank you. Good morning, John Bussey for Center for Biological Diversity. I believe I'm also appearing on behalf of Ventana Wilderness Alliance this morning, unless we have anyone from Ventana on, which I don't think so.
I do not see anyone I don't recognize. Very good. And you did appear on their behalf the last time as well. So that's great. Thank you for that. We will take that appearance on behalf of both entities and move to Trout Unlimited. All right, Carmel River Steelhead Association. Monterey Waterkeeper. California Department of Fish and Wildlife. See Ms. Miller. Let's go ahead and get her promoted.
Good morning, Kathleen Miller for CDFW.
Good morning, Ms. Miller. California Department of Parks and Recreation. See Ms. Syverson. Let's go ahead and get her promoted.
Good morning, Emma Severson for State Parks.
Good morning, Ms. Severson. National Marine Fisheries Service. All right. And the California Coastal Commission. Mr. Hammond, let's get him promoted, please.
Good morning, Braylon Ammon for the Coastal Commission.
Good morning, Mr. Hammond. Is there anyone else who intends to participate today who has not identified themselves? All right, very good. And if we need to promote any of the remaining 6 attendees to panelists, we can do that at the appropriate time. All right, so first of all, thank you to the parties for getting the joint statement together. That was very helpful. I appreciate having everything in one document. And I appreciate getting a better sense of what the scope of this hearing is going to look like as well. And I'm pleased that you all could generally reach agreement on those issues. I have a few questions and or thoughts about that. Before we get into that, I'll turn to you, Ms. Ainsley, and possibly Mr. Berliner and Mr. Schwartz for a CEQA update. I think when we met in April, the applicant had indicated that a public-facing draft could be ready by approximately July 1st, assuming I didn't require a revision of the baseline analysis, which I did not do. So we're getting close to July 1st, I guess. So how are we going with that? Where are we in terms of that document?
I'll pass it over to Dr. Schwartz. Obviously, the Montrose is continuing to work on the document. I think that we want to seek some clarification on what is exactly being released, whether it's an administrative draft or an actual publicly noticed draft. And so we have a couple questions that honestly just came up a little bit in the last week when we were checking in with each other. We realized that we may have interpreted things from the last status conference slightly differently. So I'll turn it over to Dr. Schwartz.
Yeah, thank you. Good morning, everyone. Nice to see you. Yeah, few updates on schedule. So we are getting close. We are a little behind, and part of that is we had some additional analysis based on the earlier comments we received, including a quantitative analysis of the no project alternative that we hadn't really considered in our earlier schedule. We need a few more weeks is what we need. But this isn't endless. I know we've requested an extension before, but we really are close. We're really wrapping up just a few more pieces of the analysis. That's one thing. The other thing that we did want to clarify is if this version of the document is intended to be kind of released and noticed and submitted to the state clearinghouse, then we'll need the ADA compliance requirement for the document. And typically we wait until all the revisions for a publicly released draft are completed, because you don't want to undertake the ADA. And for those who don't understand, ADA, American Disabilities Act, this is a document formatting that assists people with disabilities to read and hear the document. So it affects tables and charts and any diagrams and margins and font size and all sorts of things that would enable the document to be read through a reader and other things. Anyway, we usually wait until that's the document's all ready to go, because you don't want to do the ADA formatting a couple times. So we did want to clarify if this version of the document was intended to be released, submitted to the state clearinghouse, in which case we would undertake the ADA formatting, compliance formatting as well.
That was my intent. Yes, was to have the next version of the document be ready for submission as a draft DIR that could go out for public comment and be submitted. We've done an administrative draft. The parties have all had an opportunity to comment on that administrative draft. I don't want to be in an endless cycle of administrative drafts and commenting in this forum. That said, my thought, Mr. Schwartz, was that when the document is complete, you would submit a complete document and ADA compliant and all that stuff to us, and then I think we at the State Water Board, since it's supposed to be our CEQA document as the lead agency, would need to go through the process of getting that noticed and submitted to the state clearinghouse. Although if you have a different idea as to how this process ought to work, as I've said many times, I'm not a CEQA specialist, and I'd like not to mess it up. So if you you have any other ideas about how I ought to go about this, I would be happy to hear them.
No, that sounds fine. What we're going to do is prepare the documents that the State Water Board can submit. That ADA compliance process, it is very sensitive. So it can't have any other changes. Once we have to run it through a third party who's going to format it for us to make it compliant, and then it will be ready to go. So at that point, we kind of don't touch the document again, and that's what we'll provide.
Great. That would be great.
Okay. So that, oh, sorry.
No, go ahead, please.
So that process takes a few weeks, the ADA compliance. And so we haven't undertaken that yet. And we have a couple more analyses to do. So on schedule, I know we were looking at a July 1 or potentially mid-July, but we're going to need probably end of July to have the document ready, and then the additional 3 weeks for the ADA formatting. We're not ready to have it formatted yet.
Okay. Let me just look at my calendar real quick. I'm gonna pick a date. Okay, so September 1st is Labor Day. And I'm not a huge fan of deadlines after a holiday weekend. So why don't we say August 29th?
Okay.
That will be a hard deadline. We won't have a status conference in between now and then. I'll just expect the document by end of the day, August 29th. And then from there, I guess it will be my team's job to get it noticed and into the over to the state clearinghouse and whatever else CEQA requires. I'll have to refresh my memory about all those steps. But let's do that. Let's say August 29th, firm deadline for that document, all ready to go. And Ms. Ainsley, go ahead and jump in, please.
Just a quick question, because I had been informed and educated about the ADA process in some small part, but is there any benefit to having someone from the AHO staff also check in to make sure that we're going to do that ADA compliance, that there's no changes in how the State Water Board does that ADA compliance. Obviously, Dr. Schwartz is very experienced and he's using a third party. People use a third party vendor because it's apparently quite difficult, complicated. But is there any way, I know that we can't obviously contact staff directly, but just to make sure that that process is only going to be done once? I was a little.
Yes, that's a fair question, and I will talk to my team internally about the issue of ADA compliance and whether there's anything we'll need to do on our end. And if that turns out to be the case, then I guess we'll communicate what we plan to do or what we need the applicant to do with the document in writing to all of the parties, and then to the extent we need to get back together, we can do that. But that's a fair question, Ms. Ainsley. We'll look into that.
Just, I mean, I'm sure Dr. Schwartz can provide the name of the, I mean, it may be that this is just all for nothing. What I'm saying is just, I feel a little nervous because I'm uneducated as to the details of this process. And so it just, if there's anything that needs to be discussed or collaborated on, and maybe, maybe the vendor is well known and that's who the water board uses, but I just feel like that now that I understand what's going on, I feel like that's a little bit nerve wracking that it could be done multiple, that it takes so long and it's such a picky process.
Yes, no, I completely agree with you. And one member of my staff has indicated to me that we have some sort of policy that needs to be followed, the details of which I'm not aware, but we will try to dig that up expeditiously and send it out to the parties, and hopefully that will provide some clarity to everyone on that issue. Thank you, Ms. Ainsley. Okay, so we'll make that August 29th. We will expect that document pending any further guidance about ADA issues from me and my team. And then on just more of the scheduling side, I obviously read the joint status report. Sounds like everyone's thinking we'll need about 3 days to deal with evidence for the hearing, and maybe an additional half day for policy statements, depending on what happens there. My thought would be, assuming we get this out shortly after August 29th, we'll need some number of days for public comment on the draft EIR, some months for you all to prepare written testimony and exhibits within the scope identified in the hearing notice that we'll issue. So I will be starting to look at dates in 2026 to conduct a hearing on this matter. I'm not sure exactly when that will be because as some of you know, I have a number of other matters on my docket in 2026 that may or may not move. But I will be picking a date. I will give you guys a heads up about the dates that I'm thinking about, so that if you have court appearances or trials, pre-planned vacations, etc., we can work around those types of conflicts and find a week with 3 hearing days that we can have a hearing in 2026. And obviously I'll schedule that far enough out so that we can have a final EIR, revised supplemental EIR, whatever this document is called, and have plenty of time for preparation of written testimony and exhibits. Mr. Bussey, you came on camera, and that usually indicates that you have a contribution to make. Go ahead, please.
Sorry, it didn't so indicate more that I had just stopped chewing. So
Very good. Okay, great. Thanks, Mr. Bussey. All right. So on the joint statement issues, I just had a couple of questions and thoughts, and let me pull this up and get it on my other screen so I can look at different things here. So I was looking at PDF page 4, and bypass flows are going to be I think one of the hearing issues in this matter, and the parties seem to at least think that those are going to be limited to evidence that was not and could not have been provided in 2011 to address the summer bypass flow issues that were left unresolved in the draft settlement agreement and the interaction between bypass flows and reservoir operations, which I think makes sense to me. And my understanding is that basically the department and Elser Ranch, generally agree on what the bypass flow should be, except for summertime. And there's some disagreement on how the bypass flows will, for lack of a better phrase, shuffle between 75 CFS and 55 CFS in the summer. There are like 7,000 old documents in here. So I pulled up the 2019, April 2019 status conference statement that was submitted then, and there was a draft settlement agreement attached to that. I feel like I've seen another version of the draft settlement agreement, but Ms. Ainsley, maybe you can just help me understand what you think is in play here on bypass flows.
Well, I'm definitely going to let Mr. Berliner chime in if I misrepresent something. But earlier, I think the bypass flows for the summer are at in the draft settlement agreement are at 17 and 23 CFS, with 55 and 75 being for non-irrigation season months. And I think that the unresolved issue, and there are plenty of parties on the phone or on the call here, are the ramping down between 23 and 17 possibly of pumping rates. But I will let Mr. Berliner chime in, but I do believe that the parties are in general agreement about the issues.
Okay, so 23 and 17. So I guess the draft agreement that was attached to the April 2019 status conference statement is not the most recent settlement agreement I should be looking at. I need to re-find that document, and
it should be.
It should be. Okay.
That number remained the same. I think some of our earlier status conference statements in this hearing had identified, I think there were three, coming out of 2019, I think there were 3 unresolved issues that were probably highlighted in that document from April of 2019. But I think at the start of the AHO proceeding, that was decreased to 2. And I'll let Mr. Berliner chime in about what those 2 unresolved issues were.
No, you are right.
Yep.
That is, I misread the document. So yes, 23 to 17 CFS. And the parties are not into agreement as to pumping reductions during the step down. Okay, good. All right. At least now I'm oriented to the correct portion of the document. Thank you. Mr. Berliner, go ahead, please.
Sure. Thanks. And my apologies for not being on the video portion.
No problem.
So I think that's correct, that it's the step downs that we don't have agreement on. But part of that, frankly, is the way that the wells are currently set up with the pumps that they have. They are not capable of fine tuning. So it's not like a rheostat on a light. And when the reservoir gets built, I've had discussions with Provost and Pritchard, the contractors for the reservoir, and it's their intention to redo the controls over the pumps to provide basically a higher level of control. We don't know exactly what that is yet. We would be working with them, assuming it's no more sensitive than it is today. I think it's pretty questionable as to whether Mr. Hill is going to be able to fine tune this beyond any level that it currently sits at. And we would need, I would say, a pumping test or a well test of some sort to determine, as when the flows are between 17 and 25, 23 and 17, what exactly he can physically accomplish. And it's not a straightforward thing to just say, oh, I turned it on and here's what I got, because it relates to what's being irrigated in terms of some fields are higher or some fields are lower, some fields are closer, some fields are further away, all of which are affecting this interim period until the reservoir is built. So that's kind of the challenge, is to bridge between today without a reservoir and tomorrow with the reservoir, because once the reservoir is in, there's going to be a great deal more flexibility. So that's the challenging part, is so what are we going to do with that? And we may just, to some degree, be at the mercy of whatever the electronics are and the physics are involved in that pumping. So he may be able, for instance, just by way of an example, I don't know that this is actually the case, that he can drop it, let's say, from 23 to a lower pumping rate at around 20 CFS, and then at 17 just shut off, because he just doesn't have the flexibility to ratchet down. When we first started going down this, we thought, oh yeah, well, we'll just ratchet down. You know, each CFS or a couple of CFS will just ratchet down. He doesn't have that degree of fine tuning on this. So we're just going to try to come up with something, and you know, once we've got something more concrete, we would discuss it with everybody.
And potentially submit what you need to submit as evidence on the, you know, the feasibility issue, we'll call it, depending on how this all shakes out. Okay, I'm processing what you're saying, Mr. Berliner. Thank you for that. Ms. Miller has her hand up, so Ms. Miller, go ahead, please.
Thank you. Yes, I think that 2019 statement, the November to April bypass, we did have meeting of minds on that. But for the summer bypass, I think the department's been very clear throughout this process that we do not agree with the step down and the 17 to 23. So I think the issues for summer bypass might be just a bit broader, just that the department, you know, at this time would not be operating within that step down. It would be something advocating for something else at this point.
Understood. Yeah, but so generally, other than that issue, is it fair to say that the department and the applicant, you know, are sticking to the settlement agreement, that those are going to be, you know, terms essentially in whatever permit is ultimately issued? You guys are okay with that, and we're limiting the scope of evidence that's going to be submitted as to what the summer bypass flows should be, or is there more on bypass flows that we'll need to think about?
Yes, it would be focused on summer bypass.
Okay, very good. And then so my next thought would be that you know, the settlement is great that you guys agree on that stuff. I think the board is going to need to make independent findings that the agreed upon bypass flows are protective of public trust resources. I don't think we can just ratify the, you know, settlement agreement without some evidence on that. And presumably, I would expect some combination of the applicant and other parties to be submitting at least some evidence that would allow the board to make those independent findings. And I see Ms. Ainsley nodding and Ms. Miller nodding, so that's great. And then I want to turn to Mr. Bussey and the other NGOs to the extent they have anything to say about this. Do you have anything to add, or we all, even the NGOs, are in agreement that the issue on bypass flows this hearing is going to address or are limited to the summertime bypass issue that we just talked about? I saw Chris Schutz just come on, but for my part, yeah, I think that summarizes the scope of the disagreement on bypass flows. I think it's fair to say that we share that characterization, but yeah, Chris, if you have anything to add to that.
No, I think that's a correct characterization of the scope of disagreement.
Okay, that is great. Thank you for helping me through all that. Okay, I think that does it for that issue. I will just say, I totally understand and agree that the scope of this hearing, we should not be redoing issues and evidence that were appropriately heard in 2011. That all makes sense to me. And I think you guys all did some kind of closing briefs at the end of that process. It will be, and I'm just previewing this, there will be information in the hearing notice about closing briefs, but it will be, I think, very important for the closing briefs in this hearing to do a good job of relating back to the 2011 record and, helping me work through that. There's a lot going on, a lot of time has passed. And so, when you guys get to the end of this hearing process and you're submitting closing briefs, please do your best to help point me to every location in the record where I need to make, findings in an ultimate order that approves everything, because that is going to be a challenge for the hearing officer to come through all that. As you know, I was not working at the State Water Board, let alone the assigned hearing officer, circa 2011. All right, that's my free advice for the day. Mr. Schutz, go ahead.
Yeah, just in that vein, even though some of us were actually there in 2011, after an interim of 14 years, we'll have to review the record because it's not exactly at our fingertips as well. So I'd hope that when you come to assign a time frame for closing briefs, you take that into account, recognizing that we all want to get this done.
I certainly will. I will probably do longer than my standard 30 days for that reason. I have been in that position and I am sympathetic, and I'm sympathetic now. Thank you, Mr. Schutz. Okay, and then on Water Code 1004, and that issue is coming in, I think, to the extent parties are going to address further the intent and meaning behind Water Code 1004 based on the ruling letter that former board member Dodick issued some years ago. I've read these arguments a number of times now, and I guess I'm not entirely sure whether we need a full evidentiary record to interpret a statute using legislative history and other seemingly judicially noticeable materials. But in any event, what I expect I would do for this hearing is, to the extent possible, collect those legislative history materials that were cited in that ruling letter, make them AHO exhibits, and then if the parties want to submit, hire historians or whatever and submit testimony interpreting those materials or supplementing them, you'll go ahead and do that to the extent you think that's a good use of time. Anybody have any concerns about making those materials AHO exhibits? Ms. Ainsley?
Apologies, I had to go back and read it. My memory was that it wasn't just legislative history that was cited. I seem to remember like older, maybe bulletins or agricultural bulletins and issues like that. I think our main concern is that we properly get a chance to challenge even the admissibility of some of those. So I don't know that I would agree that all of them should just be marked and admitted as evidence. But I will admit that as I sit here today, I don't have a list in front of me of what was cited. I just recall that there was, so I believe.
Yeah, there are some.
Oh, go ahead.
Yes, I was going to say, yes, there are certainly some ancient documents that would not be outside, or that would not be deemed, purely legislative history materials. And Ms. Ainsley, when I say, submit them as AHO exhibits at the end of the hearing, I'll take motions to move exhibits into evidence. Presumably, someone will move the AHO exhibits all into evidence, and then that will be the party's opportunity to say, no, this shouldn't be admitted because of X, Y, or Z, you know, technical evidentiary reasons. So you will have that opportunity. Just my designating them as AHO exhibits does not mean that they are automatically admitted into evidence. So you will have that opportunity.
And then I think that our other point in that was that we were hoping to keep this somewhat constrained, that we of course intend to put on evidence regarding that additionally cited. We put on testimony regarding that additionally cited evidence, but since I believe only 2 parties in the original hearing put on evidence of 1004, although I think maybe other parties briefed it, but maybe other parties put in, but we would keep the evidence from 1004 from the prior hearing. So I would expect that parties that did not put in any evidence of 1004, you know, that this is more of a limited scope. We're not rehashing all of 1004. We're rebutting the evidence that was cited.
Yeah, we are not going back and redoing the entire 1004 issue. I don't think that's not my intent. It doesn't appear to be the party's intent. I would think that the scope of that issue would be, and I'll need to figure out language in the hearing notice to make this clear, but limited to addressing that 2020 ruling letter and the interpretations therein. No, I don't imagine we would start from scratch on 1004 any more than we would on any other issue. All right, and then I guess the other, the last issue here is, and it's not really an issue. It's you folks have indicated that this will be a 3-day hearing, which is fine with me. That will be, well, I don't know how much additional evidence is going to be submitted, but in my experience, hearings tend to take longer than I always think they will. But if you guys think you can do it in 3 days, that is great. I will appreciate the efficiency. Mr. Schutz and probably Ms. Miller are familiar with the AHO's chess clock approach and other proceedings. I am highly likely to continue doing that approach in this proceeding. And just a brief explanation, and probably all the lawyers on are somewhat familiar with the chess clock approach to hearings and trial. But I will essentially, in those 3 days, you know, take a number of you know, feasible hearing hours within the 3 days. You know, if you factor in some breaks and a lunch break, you know, you're probably looking at 6 to 6.5 hours of actual testimony time a day. And I will, in the hearing notice, divide that time amongst the parties, and that will be the parties' total amount of time to accomplish everything they need to accomplish in terms of their evidentiary submissions and opening statements and objections. So, you know, just by way of example, and I'm not suggesting that this will be the allotted amount of time, but I may say, okay, CDFW of the, call it 19 hearing hours in 3 days will be allocated 3 hours, and that will be the total amount of time for CDFW to put on an opening statement, direct testimony, conduct cross-examination of other witnesses, and make, you know, oral evidentiary objections throughout the hearing. We'll, you know, run a number of timers and track that time. I suspect CDFW may end up getting more than 3 hours, but it's just an example, Ms. Miller, so don't bite my head off now. But that's the way I intend to run that hearing. So I just wanted to preview that for the parties who have not been involved in AHO proceedings where we've used that chess clock approach. And to the extent that explanation makes you all think that you may need more or less than 3 days, think about that in the next week and let me know. I'll probably be issuing a hearing notice that attempts to allocate that time by the end of July. All right, are there any other issues that any of the parties wanted to raise today before we adjourn? And Mr. Schutz, I see you are off mute.
Yeah, just one question, Hearing Officer Bivens. Before you allocate time, would it perhaps be prudent to see what evidence comes in and how much may be at play so that, folks can understand how much time they might need to cross?
Yeah, it very well might. I'll give that some thought. I mean, the other thing I could do, frankly, Mr. Schutz, is allocate the time as seems appropriate now, subject to change later. Although, as I say that out loud, it's probably better for me to just wait until you've submitted the evidence rather than having people ask for more time later. Then I can make a final allocation. So thank you for reminding me of that. Okay, any other thoughts from any other parties? All right, with that, so I think action items on that have come out of today's status conference are: one, we will look for well, actually strike that. One, me and my team will attempt to find this policy about ADA compliance and whatever other noticing stuff we need to do on the CEQA document, and we will make that information available to the parties in the next week, so that by August 29th, we will have a draft EIR that can be issued publicly and made available for public comment, et cetera. And then by the end of July, I will be issuing a hearing notice for this matter sometime in 2026. To the extent parties have major and irrevocable conflicts in 2026 that I should be aware of in scheduling a hearing, please let me know what those are over the next, let's say in the next week. By next Thursday, where is my calendar? I'm on the wrong month. By next Thursday, July 3rd, please let me know if there are any dates I should be not scheduling a hearing for in 2026. And I'm talking about trials and, pre-planned vacations and stuff like that. And with that, I think that covers our action items. So thank you all again for your participation this morning, and we are adjourned.